Hello and welcome to Let's Talk with Dr. Shanessa Fenner. I'm your host, Dr. Shanessa Fenner, and today I have a very, very special guest. She's just as sweet as she can be. I love her to death. I have Judge Laura Devan. How are you doing today, Judge?
I'm doing well. Thank you for having me.
Thank you for coming. I'd like for you to first start off and tell the audience a little bit about yourself.
Okay, well, I am a district court judge here in Cumberland County. I was born in New York City, won't say when. Grew up in the Northeast. I grew up in New Jersey mostly and a little bit overseas. Back and forth. I lived in England for a while when I was a child, so that was interesting. Went to college in Pennsylvania.
Okay.
And then moved to North Carolina in 1989. My parents actually retired down here and I followed them.
Okay.
And ended up in Chapel Hill and went to the University of North Carolina, Chapel Hill, for law school. So I've been in North Carolina for quite a long time now. And then while I was in law school, I met my husband.
Oh, wonderful.
Yes, Jeff Knoll, who is a attorney here in town. He's a defense attorney, traffic attorney. And he was a Spring Lake baby. He's a Spring Lake native. His mom was a teacher at Manchester Elementary there. And after we graduated from law school, he said, well, why don't we go back to my hometown? And so that's what we did, and we came back here and have been here since 1995.
Okay.
I am also a mom. I have an 11-year-old daughter, Rachel.
Oh, she's in middle school?
She is. She is in 5th grade, so we are enjoying middle school, and social studies and math is all getting a little bit harder. And so I'm a very, very proud mom. And then, as I stated, I am district court judge. I've been a district court judge. I'm going on 7 years now, I think, since 2008.
Okay. Now if someone's watching and would like to know the process of becoming a judge, can you talk us a little bit about the process of it? You know, I know you have to go to school a certain number of years, and then just talk us through it.
Sure. Well, definitely I would say, you know, starting out in school, if you want to become a judge or aspire to become a judge, I would definitely encourage folks to work hard and to study hard. Grades will be very important. Obviously, you have to have a college degree and then go to law school. Some folks do it in shorter periods of time, I know, both college and law school, but typically it's going to be a 4-year college degree, and then law school is 3 years. Okay. To get into law school, there's a process of taking an LSAT exam and obviously having a certain GPA. So all of your grades through college are very important. Doing well in the LSAT exam is very important, kind of like the MCAT for medical school, and the SATs in high school for college. And then after you complete law school, you have to take the bar exam. And the bar exam is, it can be slightly different in different states, but it's about a 2 to 3 day test. Very hard, very difficult.
That's what I asked you, that is it hard?
Passing the bar, yes.
Okay. Now, do they give you scenarios or what? How does?
You have a standardized test, and different states are different, and then there's also essays. You study, a lot of folks study for about 3 months. I mean, I studied probably May, June, and July, and so you study quite intensely nonstop. Okay. And if you pass the bar, you are then allowed to become a lawyer. Okay. And judges typically have been lawyers. There might be still a few places in the states. I'm not sure that we may still have judges that are not lawyers, but typically you have to be a lawyer first. Okay. And then it really can vary. The federal system and the state system varies, and different states vary. So you can see judges who are appointed or elected. In North Carolina, our judges run for office. We have district court judges have 4-year terms. We were elected. Some of us may be originally appointed. I was originally appointed by Governor Easley to a new seat, and then I ran. But we run for 4-year terms. And then you'll see the federal judges, you know, who are appointed. And some states, the judges don't run. They're appointed, and they have retention systems. So there's a lot of different philosophies on that, whether or not judges should have to run or not run, and different approaches to that and different philosophies because of the nature of the job, the nature of the office.
Okay. Now, is there a certain number of years that you have to be a lawyer before you become a judge?
No. You know, we have, I think we had one district court judge here, one of the youngest judges. I think he became a judge at 29. And we have some judges that have practiced for a few years. I mean, technically, you could come out of law school and pass the bar and run for judge. That could be your first job.
Wow.
It'd be a question of whether or not, you know, a governor wanted to appoint you, or whether or not the the electorate wanted to elect you with that experience, but you could do it.
Okay.
Yeah.
Okay, that sounds promising. All right. So what is the role of a judge?
I think the role of the judge is to help society deal with its conflicts, essentially to settle and resolve conflicts in a peaceful, efficient manner. So if you have two people that have a dispute, they can't agree, they go to the court system, they present their cases, the judge listens impartially to the facts of the case, is knowledgeable as to the law, applies the law, and then makes a ruling and makes a decision. If a person breaks a law, commits a crime, a victim, a defendant, and the state wishes to prosecute that, we listen to the evidence and we determine whether or not that person did, in fact, break the law, rather than having a different resolution, outside of the court system. There obviously are alternative dispute resolution systems where conflicts can be resolved differently. We do have ADR and mediations, but fundamentally the system is for, I think, for conflicts to be resolved efficiently and peacefully and safely.
Okay,
hopefully.
all right. Now, Judge, when did you first realize you wanted to become a judge?
I think I first realized I wanted to become a judge probably around the time that I was in 8th grade and then 9th grade. I did a mock trial class and just fell in love with it. Just loved being a lawyer and doing the research. I think I went a little bit overboard. And the class, it was very clearly the type of case which was supposed to come down one way or the other, and I don't know if I made my teacher exactly happy with, because it was kind of a morality issue, but I just really enjoyed it and loved reading, loved research, loved writing. My parents said I loved to argue and debate. So it was a combination of that, and I think I saw some movie in 8th grade that I really enjoyed too, but it was that mock trial that I did.
Okay, all right. Now, you do family court law, right? Is it correct?
Yes.
Okay.
Yes.
Can you tell us a little bit about that?
Sure. I am in district court, and technically district court judges can sit in all the parts of district court. Family court is one part of district court.
Okay.
Family court is a system that's designed to help families and children who are going through transition, going through difficult times. So typically a divorce or the breakup of a relationship, the breakup of a family. And the idea was to have more services for those families, be more aware of the problems that those families go through. There are different types of cases. They need more special attention, especially because children are involved. There's more services. One of the ideas of it also is to have case management, a team that kind of works with the family, a case manager, a particular judge that works with the family. There's also timelines, case management. Cases in the past could have lingered in the court system for a very, very long period of time. And that's not good for families. It's not good for children. If you have a mother and father who are getting divorced and their case lingers for 3 to 4 years, that family doesn't really know where they're going. That child doesn't know necessarily where he or she is going to live, what school he or she is going to go to, which, as an educator could be just devastating for a child. So there's the idea of let's really watch these cases and track these cases and let's move them along. We have temporary hearings and permanent hearings, but let's move them along efficiently. Let's watch our time and let's get them on the docket. If they're not going to settle, let's have them try. So this family has closure and they can move on with their lives. So I would say case management, time management is a very important element. Another very important element of family court is the one judge, one family model.
Okay.
You will have seen cases in the past where, let's say, one family, one case may have a total of 10 hearings is possible between temporary hearings and permanent hearings. Very easily possible. If you have temporary hearings, motions to modify, reviews, things of that nature. And that family could then potentially, if we have 10 district court judges, be before all 10 different judges. The idea is to get that family linked up with just one judge and say, okay, well, the Smiths are going to be with Judge Devan. And I know the Smiths. So when the Smiths walk in my courtroom, I say, oh, okay, Mr. and Mrs. Smith, where are we at? So for example, at a temporary custody hearing, if the Smiths have been involved with the Department of Social Services many times, and there's a big stack of Department of Social Services records, and it takes me 4 or 5 hours to read those records, the next time I see the Smiths, I don't necessarily have to read those records again. I will remember the Smiths. I'll be familiar. I will have probably notes somewhere. I can review them. Things will come back to me. If that case then goes to Judge Tony King, another one of our family court judges, or Judge Steele, they're going to have to read those records all over again. And that's not efficient. That means that's taking time from hearing another case. So the idea also is sort of one family, one judge. We don't always get completely to one judge for all of the cases, but it does tend to work better. I know the family when they come in. Also, if I speak to a child in chambers, let's say at a temporary hearing, I meet with the child in chambers, 1 or 2 years later when we get to the permanent resolution, if the judge speaks to that child in chambers again, I'm the same judge. So if I see, Tommy Smith back in 2012, and I see him in 2014, it's maybe not as scary of a process for him because he's coming back and seeing the same judge. So it's kind of that management, time, and services for that family, which will hopefully make what can be a very, very difficult process, very intimidating, emotional process, hopefully make it more user-friendly and more efficient for a family.
Okay. Now, Judge, how do you know, and I know you have to make the decision about whether or not the child goes with mom or dad or visitation and everything, how do you know, and what do you consider or what do you look at when you're making that decision? Because that's a very, very important decision.
The guiding law is the best interest of the child. That is the overall guiding principle. What is in the best interest of the child or children? You also look, obviously, if the parents are fit and proper persons to have custody. There may be a parent who is simply, for some reason, just not fit. We may have an addiction or a mental health issue that just makes that person just simply unable to care for the child, unfortunately. Other than that, if you have two fit and proper persons as parents, you really are looking at the best interest of the child. And you're going to look at a variety of things. You're going to look at, typically, when it was an intact family, who was the primary caretaker of the child, who really did the day in, day out caretaking of that child, the dressing, the bathing, the feeding, the taking to school, who knows the child, who's bonded to that child. That can be very difficult because in our society today, quite often, it's both parents are very, very well bonded to the child. We also look at things like school records, who's been involved in school, how is the child doing. For me to have a school teacher or a principal or a guidance counselor come if I have a conflict case between two competing parents, their testimony is very valuable. So the parent that is pursuing the academic progress for the child is very important. The parent who's involved, cares about homework, cares about grades, has a relationship with the teachers in the school. Again, sometimes, quite often, it's both parents. We also look if there's Department of Social Services involvement, if there's been child maltreatment or neglect or abuse. We look at those records. Obviously, that's a very serious issue that would come up. We look at medical records, if there's been any special needs for the child or who's really pursued the medical caretaking of a child and the dental health of a child. Unfortunately, there's some parents that can be very neglectful as to those issues. Mental health issues we also look at. If a parent or parents have mental health issues, quite often we will have psychological evaluations performed to see if there's any concern there, or treatment needed, or if there's psychological issues for the minor child. So it's really a global approach. You really kind of want to look at every aspect, the life, the day-to-day living arrangement for the child that the child is used to, who can provide a stable home environment, who is going to nurture and look after all the needs of that child, emotional, mental, academic, every aspect of where you would want that child to be well taken care of.
Okay. Now, Judge, do you all ask the child where he or she would like to be?
No, typically not. We try not to ever put that decision or the choice on that child. I'm a really big believer in children having childhoods and adults being adults. And I think you only get one childhood, and I think it should be fiercely protected. The law is if a child is of suitable age and discretion, they can express a desire as to a preference. And that is one piece of evidence that the court can take into consideration, but not the deciding factor. I have had children who have expressed a desire to live more with one parent, but that's not necessarily in their best interest. That might be a parent that doesn't have a curfew or doesn't care if a boyfriend or girlfriend comes over. They might want to be with the easier parent, the parent that doesn't have discipline. So that's just an example of where that would not be the guiding principle. But certainly if a child has a desire, they feel safe or secure, you just kind of get a sense of what the balance is there. We generally in Cumberland County do not put children on the stand to testify. Typically, parents will consent by and through counsel for the judge to speak to the child in chambers, off the record, in the presence of the clerk. And I think what I do, and I think what most judges do, is we just have a conversation. We just touch base, see how the child's doing, talk about life, and get a sense of how things are going, what's going on in their households, what they enjoy, what they don't enjoy, what they would like to change, what they would like to stay the same. And you know, kids talk, and
Yes,
they give you information, and they're very smart.
Yes,
and,
they are.
And I think they should have a voice. It's not that they shouldn't have a voice and they shouldn't have a choice. I just think they should get to still be children.
Okay. What have been some of your hardest cases? The most challenging ones?
You know, sometimes the most challenging cases are definitely custody cases. They are the cases that my bailiff said this to me the other day, I truly agonize over, I truly lose sleep over. Because it's a child, and it's the future of that child's, that's the child's life and their future. Some cases that are very difficult are when you have two very good parents who live far apart. If they live in the same town, it's really not a problem because we can do a shared custody arrangement where they really have, and I like shared custody arrangements where the child can spend almost equal time in an efficient way with both parents. But two excellent parents who maybe just live very far apart or just really cannot co-parent. Difficult cases are also two parents who are maybe not necessarily great parents, not the best parents in the world.
That's right.
And you're concerned about placing a child with either parent. Those can be very, very difficult cases.
And then what do you do with that, Judge, when you have, you know, you're apprehensive about both parents? Do you then look at the grandmother or the aunt, or how does that normally
Well, I
play
can't automatically place the child with another party or another person if they are not a party to the action. And if the Department of Social Services hasn't filed a petition to place the children in foster care, technically you're in the court system with the mom and dad. What we normally do is put safety parameters in. Typically, if I have concerns about both parents, I will want typically the child to be enrolled in a school, a daycare, or a public school system where I know there are professional third-party eyes on the child, perhaps not being homeschooled or home all day. I will typically order the child to be in counseling with a professional licensed counselor, so that child has a touchstone, a third party to go to and speak to. May order the parents to have counseling. I try to put as many safety parameters in place that I can think of. Particularly for me is having third-party professional eyes on that child. So if something is not going well, that child has an outlet. They're in a public school and they can go speak to a teacher or a principal or a guidance counselor, or they're seeing a counselor and they can tell that counselor how they're feeling if things aren't going well at home.
Okay. Now, Judge, what about the cases where maybe domestic violence is a part of it? Maybe you have a parent that has beaten, you know, one of the family members, or has beaten the child, or possibly the mother, or vice versa. You know, how do you, you know, make your decision about things like that as well?
Those cases are very difficult. I mean, it can obviously rise to the level if a parent beats a child or abuses a child to the point where they have no custodial rights. And they do not get to see the child or spend time with the child. If it rises to that level, that will typically be in juvenile court or DSS court cases. But those are all certainly parameters that would limit a parent's access to that child. Domestic violence in the presence of a child between intimate partners is child abuse. So when one intimate partner abuses the other parent or partner in the presence of that child, even if they don't lay a hand on that child, obviously that is abusing the child as well. There are folks who are very toxic when they're together that are okay when they are apart. And we just figure out ways that we keep them apart. We don't let them exchange the child, or we have third parties exchange the child, or we exchange the child at safe locations. I will have victims of domestic violence who will come in and say, my husband is not good to me, but he's really very, very good with the child. I have no concerns with him with his child. And you have to listen to both parties and put in as many safety parameters as you can put in, and hope that you're making the right decision.
Okay, which leads to my next question. How do you leave your personal views and opinions about stuff out of the cases when you're making the decisions?
Well, first of all, I think this is a very serious job, and you take an oath. You swear on the Bible that you are going to uphold the Constitution and the laws of this state, and that is your job, and it is not your job to put your personal views or feelings on your cases. Obviously, we're all human.
Yes,
Obviously, we
are.
all have subconscious. We may subconsciously, and I know I am certainly not perfect by any stretch of the imagination. I think you try to remain very cognizant of it, very aware of any biases you may have, any opinions, any feelings you may have. I really try to check myself. I try to be very aware of it. I try to just be very conscious of it. I read. I try to stay up with the law very carefully. I am a person who meditates. I exercise. I just think you need to be very, very aware of keeping your personal views out of the courtroom.
Okay, because I know it's very hard, because sometimes you can listen to someone talk and you're thinking to yourself, oh, he's lying or she's lying. I mean, we're human. So I just wanted to know, how do you, because, you have your opinions, like, for example, domestic violence is something that, I don't tolerate, So it would be very hard for me if I were a judge, I know it would, to stand there knowing that a man has been beating his wife and child, and then for me to, be able to not think about that, and just, it just would be very hard, because I know.
Well, it's not a question that we don't obviously not think about it. I do think it's a balance of, you would have to see each case by case scenario and the facts. If there is a father who has beaten his wife and his child, it would be to a degree that I don't know that he would have any relationship with that child. It would really, really depend on the facts of what had happened. Because you are always obviously still trying to maintain, if possible, a relationship between a child and his or her parents, because their roles are very important. We can order classes, and people can get help and change, but there are cases that make you angry, and you've got to be very careful. And I know I probably have said things at times that maybe I should not have said, because we're human. But you do really have to be, I think, just work on constantly evolving and constantly being aware. And I think reading and meditating and studying and being aware of things like that. I mean, I really stop and pause before I take the bench in the morning. For me, I like to run. So I really like to run in the morning and really think about my day out when I'm taking a run, and then go on the bench with kind of a fresh slate and open mind, hopefully.
What about cases, Judge, that may involve sexual molestation, which is another thing that I really can't tolerate, messing with little children? How do you handle those as well?
I typically do not hear those cases. That is typically in juvenile court, DSS court. I do occasionally get a case that crosses over. Those types of cases, when a child has disclosed, you are typically going to see DSS will have filed a petition, and they'll be in the juvenile court system. Our Judge Tony King and Judge Pone sit in those courts. Those are obviously very serious cases, and a question of whether there can be any type of reunification with the parent that does that is obviously a highly complex issue. But those are the types of cases where you'll see parental rights can be terminated, and there's no contact between the perpetrator and the child. But we typically don't see those in family court that often.
All right. Now, what are some of the things you do not tolerate in your courtroom, Judge?
I like a quiet courtroom, and I like a polite courtroom. I like a pretty formal courtroom. I think courts are there's just some places that are left in our society that just need to be respected, and there needs to be formality. I'm certainly not saying court is church, but I tell folks, I used to tell my clients when they were coming to court, you need to dress like you're going to church, and you need to be respectful. Obviously, it's very different, but we still need to have places in our society that are revered and respected and honored for the preservation of our society and our systems. I don't, for example, I sit in 3A a lot, which is our domestic violence courtroom, which can be a very big courtroom. We have a lot of people that come in and represent themselves pro se. They don't have lawyers. And they come in and they get a restraining order, and they sit on the stand and they tell their facts. And sometimes it's not the prettiest facts in life that you've ever heard, and people do some silly things and some eye-rolling things. My job is to listen. We have young people sometimes, and I will get people out in the courtroom that laugh, kind of do a snicker, and laugh. I can't stand that, and I will call them out like they are kindergartners. And I, tell them I'm going to have my rules hanging over my head. Treat others the way you want to be treated. Keep your hands to yourself. The things we learn in kindergarten. And I said, when you get up here and you tell the facts in your case, just imagine the courtroom laughing at you. So that's just a personal thing. I cannot stand when people laugh or make noises, because for folks to take the stand and tell some of the most embarrassing things that have happened to them when they are asking for help, and then to be laughed at. So that's just a personal thing for me.
Okay. Now, Judge, I've got other judge friends as well, and they've told me that sometimes people come into court and they'll have a shirt with marijuana on it. I mean, it's just unbelievable. Have you had any situations like that?
Oh, I've had people come into court with statements like, I hate authority, or, but we have First Amendment freedom of speech, and I figure, well, if you want to come into court and that's the way you want to present yourself, that is your choice. That is your freedom. That's the way you want to go through life, and I still just try to listen to the facts of the case. But yeah, unfortunately, I think sometimes people think it's funny, but it's certainly, it's rude and inappropriate, and may affect their credibility when they testify. But
okay, Judge, if someone's watching, what is the most challenging thing about being a judge?
Children. The children that come through the court system, and worrying about the children in custody cases and abuse neglect cases, the children that are hurt and exploited, and making sure that those cases are getting into court, being litigated properly, all the evidence we need is coming before the court, and that we are making the right decisions and putting those children in a safe place. I just think that's one of the most important roles a judge can have.
Okay.
Children coming through the court system. Also children charged with crimes coming through our court system, young people, juvenile delinquents, and getting them services and help, and hoping we set them on a new path, but cases involving children.
Okay. Have you ever made a decision and then you went home and slept on it and felt like it wasn't, the next day you didn't feel like it was a good decision?
Yes,
okay.
Absolutely.
Okay. Now, can you go back and change it? I mean, what's the process for that? Do you just have to?
Yes, you can change it. I mean,
okay.
if it's an order is not an order until it's reduced to writing and signed by the judge and filed with the clerk of court. I have one case early on when I was a judge. I remember calling the lawyers into chambers and saying, I just got that wrong.
Okay.
We're going to change it.
Okay. Well, Judge, thank you so much for being my guest. Would you like to give the audience any kind of contact information or something? Do they have a question or something in time?
Well, district court can be contacted at www.northcarolinacourts.org for information, and we are in downtown Fayetteville.
All right. Well, I thank you so much.
Thank you for having me.
Audience, thank you for joining and looking at Let's Talk with Dr. Shanessa Fenner. Have a great day.